Okay, so like I said, my name is Justin Stivers, owner of the Probate law firm. And so what, I guess basically probably the best place to start is to talk about probate and what it is in general. So the word probate, when you hear it, what it means, unfortunately, is that someone has passed away, somebody has died. And what we're doing when it comes to your all's world, when it comes to real estate, is let's say John Smith owned a piece of property when he was alive, right? So John owned his piece of property. When he died, now either his children, let's just say, are going to inherit that property. But before they can get title to the property, it's got to go through a court process called probate, which there's a judge, there's going to be an attorney, and at the end of the process, the judge is going to say who the new owner of the property is. So whenever you hear the word probate, for it actually to be a probate, someone has to have passed away, someone has to have died, and then we're going through a court process, and at the end of it, the judge is going to say who gets what. So there might be real estate, there might be money, there might be a car, there might be, there's a bunch of different things, but just for you all right now, and since you all are realtors, we're kind of just focusing on real estate. Yeah? Okay. Another term we kind of want to know about is estate, so E-S-T-A-T-E. Estate, what that refers to is basically when someone passes away, we refer to everything that they might have had as their estate. So a person had their house, had their car, had their bank accounts. So John, when he was alive, we just called him John Smith. Now that John has died, we call him and everything the estate of John Smith.
Even though he left
A will.
Basically, it's assets of somebody after they pass away.
And liability. So if he owed money to people, that's also a part of the estate. Probably the most important term for you all to know is personal representative. So some states use the term executor. Florida, we use the word personal representative. The personal representative, and to your point, what you brought up, is the personal representative is the person who's able to sign the listing agreement. They're the person who is able to sign the as-is contract. They're basically the one who I work with in the legal part of it, doing all of the work. And then for you all, it's the one that's going to be signing any contracts and signing anything. So it's very, very important that you make sure that you're working with a personal representative, because if you're working with somebody else and they're not the personal representative, then you're kind of wasting your time. So how do you know if you're working with the personal representative? And I'm going to say PR because personal representative is long and I say it a lot of times. So we also refer to them as the PR. The PR is appointed by the court. Okay? So even if somebody has a will, which a will just basically, you guys are probably familiar with what a will is, but it's essentially a piece of paper that anybody can write, and I say, I'm leaving my house to my brother. I'm leaving $5,000 to my sister, whatever. So in the will itself, I'm probably going to name who I want to be the PR. So when I die, I want my brother to be the PR. If a client comes to you and they just give you the will and they say, hey, look, I'm the PR. Look, my dad named me the PR. That's not good enough. That's not good enough. You actually have to go to court and have the will and the judge is going to say, okay, yeah, based on this, that person is the PR. And I'll give you an example why. I have a case right now where a lady passed away and she had two wills. Okay, so she had a will that was done in, let's just say, in like 1993, in which she left the property to my client, and she named my client as the PR. However, she had a will that was done in 2004 that was different, and it left the property to her son, okay, and named him as the PR, which is fine. Sometimes that happens, right? You get older, you change your will, that's fine. And normally, in the normal course of things, that second will would have been valid. Right.
And would avoid the first.
And avoid one. However, our argument, and which we won on, is when she made that second will, she had Alzheimer's.
Yeah.
So she didn't have capacity to actually sign that. So if you had been working with the son, and he had shown you the will, and you started working with him, and you said, okay, yeah, that will's good enough, it names you as the PR, but then I come along with my client, chances of my client now going to hire you after you've been, representing the brother that she hates, very unlikely. So you gotta make sure, you gotta wait until the judge actually signs a piece of paper. It's called an order appointing personal representative, which you don't necessarily need to know. But at that point, then you can start working with the PR.
But the PR is appointed after the probate is completed.
It's the very first part of the probate.
Okay.
It happens, it's the very first thing that happens.
Gotcha.
Right, we file everything, we get the case started, and then the first thing we need to do is get the PR appointed.
Okay,
Yeah.
so if there is like no argument between two parties, it's still gonna be court appointed
Yes.
because even though there's
Yeah.
only one person, the court still has to.
Yeah, the
sign
court
off.
still has to sign off on it, yeah.
Okay.
Okay, so that's a brief definition of the PR. But again, we'll talk a little bit more about, I'll talk briefly about how to sign the listing agreement and the contracts and all of that. But just for you all to know, don't go list a property until you're 100% sure that you've got that piece of paper from the court saying that they're PR. All right.
Is that public record? No.
Yes, it's public record. It's public record. All right, so what's probably the first thing that you guys do when you get a potential listing, right? So someone calls you and they say, hey, Joe, I want to, I've got this piece of property that I want to sell, right? You probably go to the property appraiser's website, make sure that Joe is the right owner. So that's kind of the same thing that we're going to be able to do to figure out whether or not probate is necessary. So if someone calls you and says, hey, my mom just died, I want to sell her property, that's probably an indication that probate's necessary, right? Maybe she had everything titled correctly and you might be able to avoid probate, which we'll talk about. But generally, if someone says, hey, this person passed away and you want to sell it, chances are it's going to go through probate. The other way that you'll know is by looking at the property appraiser's website. So I gave you all a couple different handouts right there, the property appraiser's website. So if you look at the first one, which it is property address 11309 Southwest 200th Street. Owner,
Maria Pichardo,
Yeah.
state of.
Yeah, so you see next to the owner, you see Maria Pichardo, and then you see EST of right next to it.
Mm-hmm.
Okay. Right, no, which one shows 11309?
The second one.
Oh, that one might be stapled incorrect. Okay, yeah, you're good. So 11309 Southwest 200th Street. The owner is Maria Pichardo, EST of. 99% of the time, if you see that EST of after somebody's name on the property appraisers, it's got to go through probate. Probate might already be open, but this property could not be sold until the probate process is completed. Because Maria owned this property, and then Maria died, and so then the property appraiser, when they found out about it, they updated the public record and put that EST of after it. And now, let's say that, okay, so this is a real life case. So Maria has a daughter, right? And so the daughter wants to sell the property. She goes and gets a realtor, you go through the entire process. The title company is going to say, did you do a probate for this? Does that make sense? So this is really probably the most common one that you'll see is if you see that EST of after somebody's name on a property appraiser website. 99% of the time it's going to go through
So
probate.
how do you know in what stage of the process is it when you see that? If they need probate or not, how do you know?
Well, so I would say most of the time a probate has not been started. Probably not. But if it has, you would have to search public record and search by that person's name and see if you could find it on the court record. But chances are, if you're working with the client, you would obviously know that the probate has been started.
Usually how long does a probate start?
I'll talk about that. Yeah, I'll talk about that. But the only way you would really know is that you'd have to search the court records by Maria Pichardo's name and see if a probate has been opened. That's really the only way.
Once the probate is completed, it would then have, for
The new
example,
owner.
The new owner, okay.
Yeah, the new owner.
Gotcha.
Yeah.
Does it have any
Which would
reflection?
be the daughter? No, which would
Well, in this case, yes, but it depends on.
What kind of deal would it list?
So it's gonna it depends. It depends on what type of property it is. It's either, if it's her homestead, which are you all familiar with what homestead is, right? So if it's a homestead, there's a certain type of document that the judge is going to sign in the probate, and it's going to be you don't need to necessarily know this, but it's going to be called order determining homestead, and that's the new deed, and that's going to list who the new owner is if it's a homestead property.
If a property has Lady Bird title, it doesn't have to go to probate.
Yeah, I'll talk on that here in a second. I'll talk about that.
What was it named? Order.
Determining homestead. Yeah. But anyways, I just want you all to, with this example, I just kind of want you all to see when you think probate might be necessary. So the second example, I guess on page 2 or on page 1 for the one that she has, property address 1821 Northwest 33rd Street, owner Jesus Silva, EST of, and Maida Silva. Okay, so again, this is pretty common here in South Florida where you've got 2 people on title, right? So you're gonna have
Joint tenancy, is it?
yeah. So you're gonna have 2 people that are on title, right? We'll talk about how they can own property and whatnot, but basically, in this case, Jesus was the father, okay, and Maida was the yes, ma'am, and Maida was the daughter. Jesus passed away, which you can tell because it's got that EST of after it, right? So in this case, what happened is Maida wanted to sell the property. She gets a realtor. They go through the entire process, 4 or 5 months listing it. They go to closing, and the title agent says, no, you've got to do a probate for Jesus, your dad. And she says, well, I'm already on title with him. I'm the only daughter. Like, why is the property not mine? And unfortunately, the way they own this piece of property, and what's called tenants in common, which basically just means Jesus owned 50% of it, Maida owned 50% of it. So when Jesus died, it didn't automatically transfer to Maida, right? You guys with me?
Yeah.
Okay. So in this case, Maida had to do a probate. We had to do a probate for Jesus to get his 50% into her name, and then they were able to sell it. But she's obviously upset because she spent 4 months with the realtor doing this entire process, and then she had to spend another couple of months doing the probate process. So I use this example, partly to show that just because somebody is on title does not mean they automatically get the property. And when you see 2 people on title, you've got to make sure that they own it in a way that would avoid the probate process, which I'm going to talk about here in a second. And in this case, they just owned it as 50-50 owners. And so Maida had to do the process for Jesus. Yeah? Okay, so how they could have avoided that, how they could have avoided having to go through the probate process. There's a couple different deeds that you can do. Give me just a second as well. A couple different deeds that they could have done. One of them is what's called joint tenants with right of survivorship. So you all are probably familiar with that way of owning property. But there's a way that you can all own property called joint tenants with right of survivorship, which basically what that means is you and someone else own a piece of property. So let's just use this case. Let's use Jesus and Maida. So if Jesus and Maida, on the deed itself, if it had said Jesus Silva, a single man, and Maida Silva, a single woman, own this property as joint tenants with right of survivorship. They have that specific language. When Jesus passed away, it would have automatically gone to Maida. And when you have that language, on the deed, you avoid going to probate. So that's a very easy way that people can avoid the probate process, is by updating the deed that way to say joint tenant with right of survivorship. Another way that they could have done it is, you mentioned the Lady Bird deed. So there's 2 types of deeds that are somewhat similar in name. One of them is called a life estate deed, and one of them is called an enhanced life estate deed. So a life estate deed, what that is let's say I own a piece of property, and when I die, I want my brother to get the property, okay? But I don't want him necessarily to have ownership interest right now. So I can do a life estate deed and basically say, Justin Stivers, I own the property, and when I pass away, it goes to my brother. I don't have a brother, but when it goes to my brother, John. All right? That works, and that avoids probate, because then John automatically gets the property. The problem with that, though, is let's say in 10 years I don't like John, or in 10 years John gets married to someone and I hate his wife, or whatever. If with a normal life estate deed, I can't take him off of title unless he agrees with me. I can't sell the property unless he wants to sell the property too. So you could see how that could become problematic. So in Florida, we have what's called an enhanced life estate deed, which is also called a lady bird deed. And it's a unique type of deed, very similar idea in the sense that I can put John on title, but if I hate John tomorrow, I can take John off of title and I don't need his permission. If I want to sell it, I can sell the property and I don't need his permission. But once I die, the property automatically goes to John.
What's the wording for that?
Enhanced.
It's
The lady bird.
it's like kind of long language. There's like a whole clause, like paragraph you got to put on there. So I don't have it memorized to tell you. But so there's certain type of language that you need to put in that deed in order to make it effective. So when you change the deed that way, when you change the deed by the joint tenants with right of survivorship, the life estate deed, the enhanced life estate deed, which is called a ladybird deed, you avoid the entire probate process. The property just automatically transfers to that person.
Yeah, but when you give a life estate deed at that person's passing, the property comes back to you.
If they die before you, yeah.
But if you die before them, it goes
to them, right.
Okay.
Yeah.
Would you go as far as to say like if your client asks you like you should just do an enhanced one just in case?
Well, it depends. It depends on their situation. If they have minor kids under the age of 18, they might not be able to.
Mm-hmm.
Right? So husband and wife are married, and they want the property to go to their, child.
Mm-hmm.
Well, if Sally's only 5, she can't be on the deed herself,
Yeah.
right? So it depends on the situation.
Okay.
There's pros and cons to it. Sometimes, depending on the lender may not let you do that.
Mm-hmm.
So I can't say 100% yes.
So to refer to like you, for example.
Yeah, or the title company, the real estate attorney
Gotcha.
could do it as well. The other thing I didn't mention, husband and wife. So husband and wife, when husband dies, the property automatically goes to wife. When wife dies, the property automatically goes to wife, or whatever, but vice versa, however you said that. And you don't have to put special language. That's just kind of the default. It's called tenants in the entirety, but it's just the default for spouses.
Gotcha.
So it's assumed.
It's assumed, right? It's assumed. The one issue where it comes in though, or one time when it comes in, is let's say husband or wife owned a piece of property prior to the marriage, and so it was in husband's name only, and then they get married and they never update the deed. That property might have to go through probate. There could be an issue with that. So if you have clients maybe that purchase properties before the marriage, or for whatever reason it's only in one of their names, they may need to think about doing something so that if they pass, their spouse doesn't have to go through the entire process. Yeah. All right. So the other way that we can avoid probate is by doing what's called a trust. So if we look at our last example, property address 13926 Southwest 161st Court. So trusts are kind of like a will, which we talked about in the beginning. A trust is a type of document that says who's going to get your stuff after you pass away, right? They're a little bit more advanced than a general will. And when it comes to real estate, doing a trust is a way to avoid the probate process. So you can put in this case, if you look at the owner's name, it says Karen S. Rodman TRS, which stands for trust. So in that case, when Karen passes away, her property automatically goes to her beneficiary or whoever she's leaving the property to, and they don't have to do the probate process. One thing about the trust where I see a lot of people mess up is to remember that it's 2 types of documents. So you have the actual trust document, which is the legal document that says I, Justin Stivers, leave the property at 123 Main Street to Julia or whoever. That's step number 1. Then step number 2 is I actually have to do a new deed and transfer the property from myself. So if I, Justin Stivers, owned 123 Main Street, I need to transfer the property from myself individually and make the trust the owner of the property. If you don't do that, the trust is basically worthless, and the person receiving it would still have to go through the probate process. So if you were to look at the property appraiser on this one, you would see that a quitclaim deed was done where she transferred the property from herself to the trust and made the trust the owner of the property. That was like a lot of information on a rainy, coronavirus-filled Thursday.
So here you don't need a probate.
Yes, you don't.
You
Correct.
don't.
You don't. You don't.
Right. And you can you do the trust when you're alive, right?
Yes, you have to do the trust when you're alive. Have to do the trust when you're alive. Yeah.
Is there a limit to beneficiaries or
No.
not really? Right?
No. But in theory, you don't. I have a client right now where we're doing a plan for her, a trust for her, and she wants to leave it to like 10 or so nieces and nephews.
Mm-hmm.
And I told her, I go, listen, because in my world, I'll get, if you pass away, let's say you don't have any of this in place, right? And your parents pass away and you're one of 3 siblings, right? So I'm one of 4 siblings. Like, the thought of me being on title with 4 of my, 3 of my 3 sisters would be problematic. And so when you have a bunch of people on title, they all have equal rights. So if someone wants to use one realtor, someone else is a realtor, someone thinks the property's worth 100, the other person thinks it's worth 900, you have issues. And then you have to get the courts involved to force the sale of the property. So what I'm doing with this client is I say, okay, listen, you want all 10 people to receive the property? Great. Are all 10 of them gonna live in this, 1,000 square foot house? Probably not. So why don't we name one person as like the person who has control, give him the authority to sell it. He has to order an appraisal of the property, list the property at fair market value, and then when he sells it, divide the assets equally between the 10 of them. And, we had other language in there that we said, if after her passing, within the first 120 days, one of the beneficiaries qualifies for a mortgage and is able to purchase it at fair market value, then they can do that. But otherwise, putting 10 people on title is a nightmare.
It's a mess.
Yeah.
I have the inverse. I have 4 brothers.
Oh, really? Right. So it can be difficult, and we all get along, but still, I don't want to.
Yeah, when
I don't
it
want
comes
to deal
to
with
money, then it's
People
something
change.
else.
Yeah, people change. All right, so that's kind of part 1 of basically how to identify when a property is going through probate. Again, the easiest way, look at the property appraiser's website. If someone just tells you that they've passed away or that someone has passed away, that's another pretty good indication that probate might be necessary.
Where do
Yeah.
you look for that when somebody passed away?
What do we do?
Where?
What do you
Public
mean?
records.
You said that if somebody passes away, that's a good indicator. How do you know somebody?
No, I'm saying if somebody tells you that they passed away. I'm saying if
I
somebody.
tell you what,
No. You're not going to go look through death certificates. No. All right. So let's say now that we've determined that probate's necessary, right? So now you got to go meet with this potential seller to sell the property. There's a couple. Oh, one thing I didn't mention though. A will. So having a will does not avoid probate. So just doing a will by itself, like if you just have a will, is not going to be enough to do anything. So if I've got a will and I say I leave the property to my brother John, and I die, and John goes to the property appraiser, the county, or whatever, and says, hey, look, my brother Justin left me his property. Here's a copy of the will. The county is going to say, go hire a probate attorney. You got to go through the probate process.
because it was not. I mean, if you have a will and you have it in public record, that's not sufficient.
Wills are not public record, so wills aren't public record, and
or recorded. I mean, no.
wills are not recorded, and a will does not. It's just that's the law. A will does not avoid probate. It's a legal document that says who gets what, but it's not going to avoid the probate process.
It would just be like evidence you guys use in court or anything.
It's
to
just
support
it's the reason a person might have a will. So if someone, let's say, in my instance, let's say I've got 3 children, all right, and I really dislike one of them, or for whatever reason, or maybe during one child's lifetime I helped him out more than I helped the other people out, and so I don't want him to get part of what I have, right? Because I want to make it fair for all 3 of them. or I hate them, whatever it is. I've seen it go both ways, where I've written wills that said, I leave everything to my daughter, I specifically don't leave anything to my son. Or I leave $1 to my son so that he knows I have not forgotten him. I've seen, people can be ruthless. But anyways, but if I don't write that in a will, if I pass away without a will, the law is going to say who gets what. So first it's going to go to my spouse, then it's going to go to all my children, then it's going to go to my parents, and then to my siblings. So if there's something that I want to do a little bit different than what the law says, I might want to have a will in place just to say who's going to get what. Now, if I'm really caring about my family and I don't want them to have to go through this legal process called probate, I might do a trust or something else, because that would avoid the probate process. But having a will by itself is not going to avoid. So when you all go meet with a prospective client, someone who wants to list a property, remember the biggest thing, which we talked about a little bit earlier, is you want to make sure that you're speaking with the PR, or the person who's going to become the personal representative. Because that's the person who gets to choose the realtor, first of all, which is important. And second, that's the person who gets to sign the listing agreement, sign the as-is contract, and all of that. So when you go meet with them, I generally recommend that you ask a couple questions. First of all, you want to ask them if they have a will, right? And the reason we want to ask them if they have a will is because, let's say that you're speaking with the daughter, and the daughter's like, me and my dad were super close. I took care of him while he was sick. He said I was going to get everything, and then I asked him, okay, Sally, did your dad have a will? And I read the will, and the will says he leaves the house to his brother. Okay, well, Sally at that point is worthless to us. She's not worthless, but she's not, she's not the one who's going to be able to sign anything. She's not going to get to be the PR. So we want to ask them if they have a will, because we want to know, are we speaking with the right person, right? If they do say that they have a will, we want to ask them if they have a copy of it. And the reason is, wills are not recorded. So we could do a will right now. The requirements are very minimal. Basically, they need to be witnessed by 2 people, signed by the person making it. They generally don't need to be notarized. It's good that they're notarized, but once I do it, I could put it in that drawer, and that's it. Nobody knows about it. So I've had clients come to me that will say, hey, listen, my dad did a will, but I just don't know where it's at. Can you find it? There's not like a will.com that I can go to try to search and see if they had it. They're generally not recorded with the courts. So if they don't have a copy of it or can't get a copy of it, there's not much that we can do. So we want to ask them, do they have a will? And then if they do, we want to ask them if they have a copy of it.
So will can designate who the PR is?
It is usually going to.
But
yeah.
the estate taxes make a difference whether you have a will or you have like a trust.
Well, there may be taxes for having a trust, but I don't want to get too far into taxes. But most of the clients that you might be dealing with, the estate tax is $11.2 million. So if they have anything under that, there's no estate taxes that they're going to pay. All right, so we've asked them if there's a will, we asked them if there's a copy, and then we want to ask them what the relationship was to the person who passed away, right? So again, the reason that we're asking that is if they're the distant cousin. So if there's no will and you're speaking with a distant cousin, there's a hierarchy of who's going to get what, right? So again, it's the spouse, then it's the children, then it's the parents and the brothers and sisters. So if they don't have a will and you're speaking with the second cousin, chances are he or she's not going to get anything. So you don't want to waste your time speaking with them. Does that make sense? So we're just, during this stage, we're really just trying to figure out if we're speaking with the right person. Now, your job as a realtor, let's say they may have an attorney at that time. If they have an attorney if they have a probate attorney at that time, you're gonna probably know, because the attorney's gonna tell you, or they're gonna have the piece of paper from the court that shows that they're the personal representative, and you don't really have to worry about it. If they don't have an attorney at that time, yes, you might be in a position to make a referral. Your job is not necessarily to go through everything and determine, based on everything that you shared with me, I think you're the personal representative. Because like in the example that I gave in the very beginning, there could be 2 wills, or I had a case not too long ago where I went to court and we were getting ready to have one of the daughters appointed as the personal representative, and then a son showed up, and I didn't even know there was a son, and he was apparently the son of the dad's longtime girlfriend. And so it was a huge thing. We had to get DNA testing and all of this, and he turned out not to be biologically, related. But you have stuff like that shows up. So if you just run, so it's not really your job to make that determination. Once you get that order of PR, then you guys are ready to kind of go with it.
If, let's say for example, they're unsure about who the PR is, say it's two brothers, could you just get both signatures on a listing agreement just to be sure, like, at least you're getting
Right.
who the
So
PR is?
here's what I'll tell you about that. So we'll talk like a little bit about now that you've determined who the PR is going to be. So generally, I'll talk about length of time here in a second, but generally from the date that the client comes to me, they hire us, we get all the documents signed, we file the case with the court, we get a case number. From that date, it takes about 30 days to get the PR appointed. On average, more or less, depending on the county, depending on the judge and all that.
Mhm.
But remember, you all can't really do anything until you get that order appointing the personal representative. But let's say that you go see this person on January 1st, and you know he or she's not going to be the PR until January 31st. You probably don't want to wait 31 days before having them hire you, right? Because if you say to them, hey, come back to me in 30 days, they're going to like one of the other, 55,000 real, whatever it is here in Miami-Dade, and they're going to sign them up. So what I generally recommend to realtors, and I've not really had any pushback, but ask your broker, have them sign the listing agreement as the proposed personal representative. So you put language on the listing agreement that says John Smith as the proposed personal representative. Because John is not yet the personal representative, but we kind of want to make him feel like he's with us, right? Because if you just tell John, come back to me in 30 days, he's forgotten about it. Right. He's going from here to Berkshire to Caldwell to wherever. He's going a bunch of different places before someone's gonna sign him up.
Mhm.
So what I always say is have him sign the listing agreement as the proposed personal representative.
And can you start the lease from
No.
January 31st?
Well, now, so once he signs as the proposed personal representative, you can't sell the property, don't list the property, don't start marketing the property, don't do anything. Basically, you just wait. You get the listing agreement signed as the proposed personal representative.
But you can post-date the listing agreement
No.
because you're losing 30 days.
Because when you see listings and it says probate, does it mean it's end the process or it's gone through it already?
I don't know how it appears on the MLS. What I'm saying is this listing agreement is not necessarily enforceable, right? It's just to kind of have them feel like they're hiring you, right? If in theory in 2 weeks he said that's not a valid contract, I'm not hiring you.
It closes the loop for the
Right,
for the
okay,
client.
fine. But I've never seen that happen. But in theory, that's what could happen. What I have I work with a lot of realtors. So what I've seen and what I generally recommend to them is you get the listing agreement, you sign it as the proposed personal representative. Great. Now once I get the order appointing personal representative, okay, we update the listing agreement, and John is now going to sign it, John Smith, as the personal representative, right? Once you get the order appointing personal representative, you update the listing agreement, and at that point, you're free to market the property, list the property, put it on the MLS, and do all of that. But until we get that piece of paper from the judge, it's just kind of sitting there.
And you can ask them for the piece of paper to John. You ask them for the piece of paper that says that he's a personal representative.
Or the attorney. Or the attorney. Generally, when I'm working with realtors, I'm either referring it to the realtor, so the realtor, I just send it to the realtor. I say, hey, look, here's the person. Or if the realtor's sending it to me, I do my kind of vetting process with them, and then once we get it, I'm going to send it to the client. I'm going to say, I'll tell the realtor, look, just got the personal representative. You can go ahead and list the property. Most of the time, it's not the client's not going to have the piece of paper. That's going to be the attorney who's going to have it, most likely. Yeah. Any questions on that? So, all right. So then maybe the last couple little things. So basically, when you most likely they're going to want to know how long it takes, right? So that's if you've dealt with probate at all or heard anything about probate, you've probably heard about how long it takes and all of that. So I can kind of give you guys some ideas of length of time. But basically, like I said, from the date that we get the client and everything signed up, case going, about 30 days to get the personal representative appointed, and then depending on when the person died, depends how long it's going to be, and I'll explain why. If the person died more than 2 years ago, so We opened the probate in 2020, but they died in 2017. Again, it takes about 30 days to get the personal representative appointed, 1 month. And then around month 2 or month 3, you guys are free to list the property, sell the property. So the probate's probably going to take about three months or so, if the person died more than 2 years ago. If the person died more recently, so if we opened the probate in 2020, the person died in 2019, we still 30 days to get the PR appointed, so that's month 1. During month 2, month 3, and month 4, we have to wait for what's called a creditor period. And then month 5 or month 6, we can sell the property. So if the person died within 2 years, more recently, I would say it's about a 6-month process. So that creditor period, that's a 90-day period that if John died and he owed money to Visa, he owed money to Baptist Health, he owed money, to other creditors, they have 90 days to come to me and basically say, hey, where's my money? And they're gonna wanna get paid. If there's no money in the estate, if John died and he didn't owe any, or didn't have any money, Visa's not going to get paid. The children, the surviving children, don't have to come out of pocket and pay that money. If the only asset that John had was one piece of property and it was his homestead property, that's protected by creditor, or that's protected by law, and they can't touch it. They can't force you to sell the property to get repaid. If you do sell the property, they can't get that money. That's basically untouchable. But if they have other assets like money in a bank account or investment properties, those creditors could go after that.
Are they notified like when the probate process?
Yeah, we have to publish it in a newspaper. Yeah, we publish it in a newspaper. Yeah. All right. So that's length of time. Again, depending on when someone passed away, probably going to be 3 months, more than 2 years, 6 months if within 2 years. Then quickly, some kind of marketing ideas if you guys are looking for them. I would say, it's like anything, like my business, like 90% of my business comes from other attorneys. I work with a lot of attorneys. I do a lot of speaking for attorneys, groups, different things like that. For you all, probably if you're looking at probate as a potential, lead generation, probate attorneys are generally good referral sources for you all because most every probate that we handle has a piece of property in it. And so, like myself, I work with a bunch of different realtors, but we're always looking for realtors to work with. Sure. There you go. I like it. That's great. That's great. Because most of the probates that we have a piece of property in them. So again, I can say most attorneys are not super approachable and whatnot. They're kind of a pain to deal with, but there are ways to get in with them. There's what's called the Dade County Bar Association, which is like a organization for attorneys here in Miami-Dade. They meet once a month. The probate attorneys meet once a month at the courthouse downtown. I believe on Thursdays. You'd have to. I don't know the exact time, but Google Dade County Bar Association events probate committee, and it's basically all probate attorneys. So you can network with them, get to know them, and find out. Say, hey, listen, I'm experienced in probate. I can help your clients, et cetera, et cetera. Whatever kind of spiel you do. You can buy lists. So I don't know how effective they are, but there are companies that will sell, lists. I know because I'm on a bunch of them, that will show the attorney who filed the probate, that will show the personal representative. I would suggest you contact the personal representative. It's probably easier. Like when I get an email randomly and I'm on a list from a realtor saying, hey, Justin, we've got cash buyers, et cetera, I've never been like, oh, good, I don't know any realtors, let me, use you. But I think if you contact the personal representative and you come to them, again, someone's just died, so hey, I have cash buyers is probably not the most effective tactic. I would probably come with a little bit more sympathy. Hey, very sorry for your loss. We can help you ABC, clean out the house, whatever you need to do, put you in contact with an attorney. Because a lot of times, people don't even know that they need to do the probate process, right? So like in both of these instances, with Maria's family and with Maida, they didn't even know that they needed to do the probate process. So by you kind of coming to them and giving them that information, you're already going to stand out from the other 10,000 realtors who are just contacting them saying, hey, I can help you, get a listing, or I can help you sell the property quickly, whatever. But you do want to have a little bit of finesse when you do it.
Pero how will you know who's the personal representative?
So you can get the list. It's public record, so that you can either buy the list, they sell them. I don't have any vendors specifically. I don't know. Or you search public records, and that information is public record.
Yeah, with the name you'll see all documents.
Yeah.
Like
One thing you can do is if you go to the Miami-Dade property appraiser and you search in the name box, you just put estate of, you'll see a bunch of people that are owned by estates, and that would give you like kind of a good list as well to kind of start with.
Yeah, IMAP too. You can do it on IMAP.
Yeah.
IMAP is probably the easiest one, I think.
But that's really it, unless you guys have any questions.
In terms of cost, the client would see, it's usually about